Please be seated.
Mr. Guy Smith, there's a request that you try to speak as close as you possibly can to the microphone and as loud as you can.
Yes.
Thank you. But you're still far from the microphone. Thank you so much.
I concern myself with speaking too close to the microphone because of the experience of the papers hitting the microphone, and then I get yelled at for doing that. And I recall when I first started practicing law that my mother used to scold me for dropping my voice.
Doing that.
And I apparently, so I apparently been doing it again. So it's a point well taken, and one that has been haunting me for many, many years.
Thank you.
I first of all want to make sure that something is clear, because I made a misstatement. I don't want to mischaracterize anything whatsoever for purpose of my argument. I want to be very clear about what our position is and what the evidence has shown with regard to the issue of Pal Krasniqi, which you had asked me about. And to clarify, regarding Pal Krasniqi,
Let's deal with open session.
Your Honor, sir, we're back in open session.
Thank you so much. Yeah, you are saying, as suggested?
as suggested for purposes of clarification, the testimony from witness 80 that Nasser Lika was present in Jablanica and escaped at the time of the Serb offensive in August simply cannot be the case. And that is by virtue of witness 6's testimony. Witness 6 made it very clear that at the time that he left Jablanica on the 25th of July, the only person who was there was Pal Krasniqi.
Your Honor, sorry, private session, please.
Well, may the chamber please move into private session.
Your Honor, we're back in open session. Thank you.
Thank you very much, Mr. Registrar. Yes, Mr. Guy Smith.
Yes, Your Honor. Over the years, I've tried to do that to the best of my abilities. In paragraph 234 of the prosecution brief, they take the position that Balaj held a position of authority and influence within, and I emphasize the word within, the detention facility. There's no evidence of this, none whatsoever, and as a matter of fact, the evidence is to the contrary. In order to find the joint criminal
Your Honors, we're in open session. Thank you.
Thank you so much. Yes, Mr. Karsman.
As I said, you know the transcripts, the judgment of the first trial, the testimony, and photographs of each of these gentlemen have been available in the public domain and on the internet for years. We have received information and testimony that a number of the witnesses who have testified in this case, who we suggest to you their testimony is indeed at best suspect. We're aware of previous proceedings. We're aware of individuals testifying, either because they specifically researched the information or had family members or others discuss the information with them. This is not an uncommon or unique experience, actually, in the annals of the history of criminal law. In 1989, in California, a jailhouse informant was able to demonstrate with the use of a telephone that he was able to obtain sufficient information from a number of different places, including the coroner's office, the district attorney's office, newspapers. Enough information that coupled with getting into the same cell as an accused or taking a ride with an accused was sufficient for him to testify in a trial that the accused had confessed to him. So the acquisition of the information is not something which is uncommon. In 1998, in a report concerning informers, as said by the Honorable Fred Kaufman, which is not precisely our situation, but is definitely comparable to it. Since these witnesses were motivated by self-interest and unconstrained by morality, they were as likely to lie as to tell the truth, depending on where their perceived self-interest lay. Their claim, referring to his specific case, that M confessed to May was easy to make and virtually impossible to disprove. These facts taken together were a ready recipe for disaster. The systemic evidence presented during Phase 6 of the inquiry, emanating from Canada, Great Britain, Australia, and the United States, demonstrated to me that these dangers were not unique to the M case. Indeed, a number of miscarriages of justice throughout the world are likely explained, at least in part, by false, self-serving evidence. And we suggest to you that that is precisely what occurred here, and it's precisely what occurred here with regard to a number of witnesses, not the least of which, obviously, would be Witness 80. Finally, reference was made on Monday that some of these witnesses sacrificed their safety on the altar of integrity and truth. And if I understood Mr. Rogers' argument, he alluded to decisions made on protective measures as a basis for you to make a determination about their credibility and reliability. We suggest to you, first of all, that there's no connection whatsoever between the two. And secondly, if in doing so he was making a reference to ex-parte filings or representations made in ex-parte filings, for a factor to rely on such allegations that the accused have had no access to and have never been able to substantively challenge whatsoever, would violate all legal known standards. Enough. I deliver Mr. Balaj into your hands and trust that you will, after full and fair consideration of the evidence presented, find him not guilty on all counts. I thank you for your time.
Thank you, Mr. Garsmith. Yes, Mr. Harvey.
And if we could have but a moment so that I can help Mr. Harvey with podium and other.
Mr. Harvey.
Finally, the moment we've all been waiting for. Your Honours, it is commonly said that in war, truth is the first casualty. I rather prefer Dr. Samuel Johnson's formulation: among the calamities of war may be justly numbered the diminution of the love of truth by the falsehoods which interest dictates and credulity encourages. Interests here mean bias, self-advancement. Credulity means lack of objectivity and willingness to believe, a lowering of the standards which fair-minded people apply to information of doubtful origin. So a diminution of the love of truth by the falsehoods which interest dictates and credulity encourages. That expression is absolutely on point here, where those witnesses upon whom the prosecution most heavily relies have been shown to be full of the falsehoods which interests dictate. And the prosecution's final brief, indeed its whole case, is based on encouraging credulity rather than the strict and time-honored test of proof and certainty beyond reasonable doubt. On behalf of Mr. Brahimaj, I adopt much of what Mr. Emerson and Mr. Guy Smith have said in relation to the law, the standard of proof, the burden of truth, and many of the facts such as they are in this case. So my address to you is shorter than it would otherwise have been, but there is ground I must cover out of concern for my client and out of concern for a proper evaluation of the case against him on the 4 counts that he faces before you. I'll try to avoid repetition, but I will have to go over some of the same ground. By way of example, I did not take Mr. Emerson to be holding out witness 80 as a witness of truth, merely saying that even witness 80, with all of his many falsehoods, had nothing to say to Mr. Haradinaj's detriment, and so obviously he would, to that extent, adopt much of what he said in relation to his client. Each of us has a different case to meet. The first duty of a responsible prosecutor, we say, is, or it should be, to seek out truthful and reliable witnesses who can present evidence upon which a tribunal can safely rely. They have manifestly failed to discharge that duty. The first duty of a war crimes tribunal is to rescue truth from the casualty list, to restore it to its rightful place in the courtroom, to rigorously uphold the time-honored standard of proof beyond a reasonable doubt, and to steadfastly reject any invitation to lower that standard. As we shall see, and as we have already seen, in the search for proof beyond reasonable doubt, the prosecution case and its own attempts to debase that standard will be of very little help to you, we submit. I adopt what Mr. Guy Smith said a few moments ago about, in quoting Justice Kaufman, the claims that are easy to make and virtually impossible to disprove. We all know that that is why the burden of proof lies with the prosecution. And in a case of the kind of evidence that you have heard, it's all the more important that it should do so. One of the classic techniques of war propaganda is the big lie. Its effectiveness resides in its simplicity, in its seductiveness, and in the drip, drip, drip of its frequent repetition. And we have heard that here. We have constantly heard of the climate of fear. We are told that the witnesses are frightened to testify. They fear for their lives, for their families, and there is a seductiveness in this. There's a risk that we will be seduced into believing because we all rightly share a concern for genuinely innocent victims, for the oppressed. And you've probably had the same experience that I have with colleagues saying to me in other jurisdictions, oh, you're doing that case, the Kosovo case. That's the one where they killed all the witnesses, isn't it? Where does this come from? This is the drip, drip, drip of rumour. There have been times during this retrial where, out of an abundance of caution, the trial chamber has been compelled to redact large swathes of evidence, thus shielding the prosecution case from being exposed to the public gaze in all its threadbare weakness. When my son was growing up in New York, I used to sit and watch a children's fairy tale program with him every morning called Mr. Rogers' Neighborhood. For much of this retrial, we have had to speak in witness numbers, to redact villages named in the indictment, and it must seem to the outside world as if we are living in some kind of fairy tale world. Well, it's time to leave Mr. Rogers' Neighborhood. It's time to expose the fairy tales spun by these witnesses. You've finally seen them in this retrial. You've seen witness 3, Redux. You've seen witness 75, witness 80, and witness 81. Manipulative, dishonest, self-interested, their testimony is shot through with the falsehoods which interest dictates. Not a frightened man among this happy group of people, each and every one of whom has managed to get themselves and their families enormous benefits by testifying for the OTP. You've heard the rumours of the water-filled basement, filled with salt, barbed wire. Imagine 3 whole days. Doesn't it sound like something of a Sylvester Stallone or Jean-Claude Van Damme movie? It sounds like pure fantasy, and that's what it is. You've heard of the sliced-off ear floating like a butterfly until it lies fluttering in the dust. A graphic, powerful, but physically impossible image. Comes out of a nightmare, a painting by Salvador Dali, or a surrealist film by Luis Buñuel or David Lynch. Again, it rightly belongs in the world of dreams, but not reality. And you've heard that the KLA targeted Serbs, Roma, Montenegrins, power plant workers, Catholics, LDK supporters, PDK supporters. What next? Seventh-day Adventists? Zen Buddhists? This has not been a retrial in the way in which one normally expects a retrial to take place. Again, when you say to colleagues, oh, we're doing a retrial. Oh, so you won the appeal. No, we lost the appeal. Oh. It's not a retrial where, due to a miscarriage of justice, the whole case has to be tried again. Here you have had testimony admitted from witnesses who testified, but whom you have been prevented from seeing and evaluating with your own eyes. Just by way of example, if I wanted to show you, as Mr. Emerson yesterday showed you, or the day before yesterday now, I think, showed you some witness clips. If I wanted to show you witness 6, I couldn't do so because he was granted face distortion, and therefore even in the privacy of your chamber, the images don't exist for you to look at his face, to look at his body language, to evaluate for yourselves, is this a witness whom we would rely on? All you can go by is the fact that the previous trial chamber relied upon him to convict my client on 1 count. In the first trial, the focus was the whole Dukagjin zone. There was, in fact, relatively little evidence, very little time spent in that trial on Jablanica. And the OTP never put forward alternative theories of the case in the glib way that have been done here. I refer to paragraph 243 of the prosecution's brief. And that is the one in which, perhaps for the sake of convenience, I should pull it up. It's the one in which they say essentially, well, if you can't convict Haradinaj, you can convict Balaj and Brahimaj. If you can't convict Balaj and Brahimaj, well, you can convict Brahimaj based on the fact that there were other Brahimajs who we say were acting in concert, the joint criminal enterprise theory. These alternative theories are new in this case. Okay, they're entitled to do that. But as I say, this is not a retrial in the way in which that term is normally understood. There's an invitation to this trial chamber, which we are sure you will not accept. We are confident that the way in which the OTP has pleaded their case, you will find is not to the standard demanded of a prosecutor serving the interests of justice. In this case, the entire focus has been on Jablanica, and the prosecution is put to the strict proof that everything they claim happened at Jablanica was aimed at establishing total control of the Dukagjin zone. So not simply whether or not certain things actually happened there, but what was the aim of it. You've heard very little direct evidence about Kosovo in general. The Dukagjin zone, broadly speaking, and instead the microscope has been homed in on this tiny village. It's a bit like what happens when a witness accidentally touches the screen in front of him and it zooms into an unrecognizable blur. There's the danger that this case will be taken completely out of proportion because of this microscopic focus. But it's a danger, again, that we are confident you will not fall victim to. Now all the evidence is in. What it comes down to is this. First, you cannot trust the prosecution witnesses whom you have seen. And secondly, you cannot trust the prosecution to interpret accurately the witnesses whom you haven't seen. In their prosecution brief at paragraph 44, they accept that the KLA were fighting a legitimate war of national liberation. And like any liberation movement fighting against military domination, foreign military domination and ethnic repression, they were entitled to use armed force, entitled to attack their oppressors, and entitled to defend themselves against those acts of oppression of which you've heard and which certainly in the first trial Colonel Crossland testified to in quite some detail. Here, the OTP refuses to accept, however, the practical realities of what a war of national liberation must entail. For example, they criticize Haradinaj for requiring travel authorizations for movement between villages. That's at paragraph 261 of their brief. Well, why on earth wouldn't you want to know who was moving between villages? Paragraph 225. They criticize the KLA for requiring that collaborators be reported. Well, what are you supposed to do in any war, let alone a guerrilla conflict? Ignore the fact that you have collaborators in your midst? No. They criticize targeting perceived opponents. Whom exactly do they suggest should be targeted then? I refer to paragraphs 226 and 262. The reality is, you have heard testimony from Bislim Zarapi, from Jakub Krasniqi, and from others. There were acute difficulties of travel and communication throughout this period. You have heard that at this time with which you are concerned, the indictment period, the KLA was a nascent organization and to some extent an inchoate organization, that it was a horizontal structure of command and not a great deal of command at all, testified to by Kufa Krasniqi and Colonel Crossland, among many others. And I think a very good point was made by Mr. Emerson in relation to the fierce independence of little villages. And essentially, that's all we're talking about. A lot of little villages during this indictment period coming together in self-defense, coming together to try to keep the Serbs out during the major offenses launched, particularly in May. And those are village organizations, the local village headman, the local villagers meeting in their Oda. And just as Skender Rajemitai and Bislim Zarapi said in response to Mr. Emerson's questions, the idea, the very idea that the Haradinajs could tell the Brahimais what to do or vice versa, the very idea that the villagers of Jablanica could walk into the village of Grabanica and say, this is what you're going to do. It doesn't pass the laugh test, but the prosecution asked you to take it seriously. Paragraph 56 of the prosecution brief, they cite Zoran Stijovic. Again, Mr. Emerson has done a fairly thorough demolition job on Zoran Stijovic, but I have a few more words to say. He was the MUP inspector. He was the head of the section for analysis and documentation of state security. He was, in short, a spook, a person who gathers, quote, intelligence, unquote, by the sort of methods Mr. Guy Smith has described, a blackmailer at best, whose testimony was dripping with loathing for the KLA. We invite you to revisit his testimony in detail and to remind yourselves of how many times the trial chamber had to intervene to remind him to answer the question and not just keep launching into yet another prolonged diatribe against the KLA. His bias, his malice were clear for all to see. The OTP called him apparently hoping to bolster their claim that during the indictment period, the accused jointly operated a policy and practice of launching attacks on civilians or supposed collaborators. When you actually check, as both Mr. Emerson and Mr. Guy Smith have asked you to, and I join in that, when you check the slippery and misleading footnotes to the OTP's brief, you find, in fact, that every single one of those cases cited by Mr. Stijovic in support of his claim that innocent individuals were being targeted, every single one of them falls outside the indictment period. Not one of them has any connection with Jablanica, and not one of them is connected in any way with any of the accused or other alleged members of the alleged JCE. At paragraphs 54 and 57 of the prosecution brief, they cite KLA attacks on heavily armed police paramilitary forces as if they were aimed at the harmless, unarmed Bobby standing outside the Old Bailey. This is not the real world. Colonel Crossland and numerous other witnesses in the first trial gave clear and compelling testimony about the true nature of the heavily militarized Serbian police force, the extent to which it was integrated into Serbian war against the Kosovo Liberation Army, and how out of control many of those Serbian police and their undisciplined paramilitary auxiliaries were. This is not the unarmed Bobby on the beat. At paragraph 76, the OTP say in their brief that by July 1998, DB Intelligence, that reliable and impartial source, quote, strongly indicated, unquote, that members of the KLA in the Dukagjin zone had kidnapped and killed Serbs, Roma, and Albanians who refused to join the KLA. Is this the new standard of proof? Strongly indicated Serbian intelligence, unsourced hearsay, evidence obtained by torture from the most biased commentators imaginable. It is a strong indication, we say, of how weak the OTP case is. Where might you expect to find the hard evidence that KLA forces in the Dukagjin zone generally and in Jablanica particularly had the intention to set up a detention center, however makeshift, or a plan to murder, torture, and mistreat Serb civilians, Catholics, Roma, Montenegrins, power supply workers, and all the rest? You would surely expect that if any such plan of any type were to exist, you would find it in the records held of meetings on June the 21st, 23rd, 24th, and you have those meetings and they're quite thoroughly and fully documented. People's organizational responsibilities are set out, but it's not there. These are exhibits P 190, 191, 192, 195. There is nothing like it to be found in those exhibits. Still less is there anything in those minutes to suggest that Lahi Brahimaj was in charge of dealing with collaborators, or that Jablanica was the place where this was to be done? It's not there anywhere. And I'll come back, or move on, to the opposite, which actually comes out of these documents. Lahi Brahimaj is appointed deputy head of the Dukagjin zone on June 23rd. But within days, it becomes clear that this is a mistake. This is a job he is not in a position to undertake, because he's not even there. I refer you to exhibit P218. He is not there, and he is dismissed by Mr. Haradinaj after a meeting on July 1st, where it said that Mr. Brahimaj is going to have to be reprimanded for failing to fulfill his duties and attend meetings, after a warning issued on July 4th, and then a prompt termination on July 5th, where Mr. Lahi Brahimaj is replaced by Mr. Nazmi Brahimaj as deputy commander of the Dukagjin zone. Question is, where is Lahi? Once again, you have the drip, drip, drip of constant repetition. It must have been Lahi Brahimaj who was responsible for everything that happened, or is alleged to have happened, in Jablanica. Why? Why must it be Lahi Brahimaj? Who signed the documents warning witness 6 that any further misconduct on his part would result in punishment? Not Lahi Brahimaj. That was Nazmi on the 25th of July. Who was it whom Rustem Tetai and Ramush Haradinaj met when they went to Jablanica to see what had happened with Skender Kuci? Even Mr. Emerson on Monday mistakenly said at what was then page 65, line 4, even he mistakenly said that it was Lahi, but in fact, we all know it was Nazmi Brahimaj. Rustem Tetai said clearly when asked by me, and that's exhibit P75, transcript page 3820, question, on the 2 occasions when you went to Jablanica to inquire about Skender Kuci, There was no sign of Lahi Brahimaj in Jablanica at the time, was there? Answer, no, no, no. I had no contact with him and he was not present, no. Is it perhaps the case that people at the time in the, I'm being told to slow down a bit, am I rattling on?
You probably are.
Okay. I did take the precaution of providing our live note reporters with copies of what I planned to say, and I've said, I've more or less stuck to script, but I'll slow down a bit, conscious of the time. Is it perhaps the case that people at the time, in a confused war situation, simply didn't know who was in charge in Jablanica, simply didn't know at that time who was whom? Can you afford to ignore the obvious point that with the arrest 7 years ago of Lahi Brahimaj, with the media attention which this understandably generated in Kosovo, and with the protracted history of the first trial, people today have managed to convince themselves that they saw him, whereas in fact it could have been any one of other uniformed KLA soldiers in Jablanica at the time. But of course, say the prosecution, Lahi was the leader of Jablanica. Of course, say the prosecution, Lahi was the uncle of Ramush, and therefore it must have been Lahi. Now this doesn't mean that Lahi Brahimaj had nothing to do with Jablanica. Of course, we're not suggesting anything of the sort. But we are asking you to bear in mind the reality of the time when the KLA, during this indictment period, are gradually trying to build up a general staff inside the country. The problem the prosecution does not attempt to address is the practical reality of Lahi's true role and responsibilities. Bislim Zarapi and Jakub Krasniqi testified that his responsibilities required him to be in the Berisha Mountains most of the time. Yet the prosecution say he was nearly constantly in Jablanica, nearly constantly present. Why, you have to ask. You don't even need to look at Bislim Zarapi and Jakub Krasniqi. Why is Ramush, his own nephew, saying, "You're not up to it, Lahi, you're out of here," because he's not attending meetings. He's not physically present. There has been gross misrepresentation of the actual testimony that you have heard, and that is therefore much easier to point out than the misrepresentations by the witnesses themselves in some respects. Prosecution kicks off at paragraph 4 of their brief, citing Colonel Crossland for the proposition that from April to September, the Dukagjin zone was mainly under the control of the KLA. In fact, his testimony, very forceful and powerful and compelling testimony it was that it was a, quote, fluid situation, unquote. And he said that time and time again. In that situation, the Serbs could take control, he said, whenever they chose. The situation was, quote, extremely fluid throughout, because no one side really held ground, apart from the garrison towns and things like that. That's at Exhibit P8, transcript 3030, lines 1 to 2, on 20th of April 2007. Colonel Crossland accepted that from March to July 1998, quote, the apparent efficacy of the KLA and control has been or was exaggerated in the minds of others, where in fact, on the ground, it was fairly thin. Again, Prosecution Exhibit 8, T 3032, lines 5 to 11, and 3033, lines 1 to 2. On Monday, Mr. Rogers again misrepresented the truth in this case and attempted, we say, to mislead you by citing a briefing given by Colonel Crossland in April 1998. And I refer to transcript page 2751, lines 8 to 11, where that misrepresentation occurred, in echoing, as it does, paragraph 46 of the prosecution's brief. Mr. Rogers cited the briefing given by Colonel Crossland in support of his general proposition, that's Mr. Rogers' general proposition, that the KLA murdered 6 Albanians deemed Serb sympathizers. However, what Colonel Crossland in fact said was 6 bodies were found in a forest near Orahovac on the 6th of April. One plausible explanation is that these were Albanians loyal to the Serbian regime killed by the KLA, but no one has claimed responsibility. Well, is that where we're at? One plausible explanation is cited as convincing proof beyond a reasonable doubt of something that happened near Orahovac, not near Jablanica. Mr. Guy Smith also drew attention to what Colonel Crossland in fact said. I would add only this. When he said, I'm quoting again from Colonel Crossland, in the Limai case, we did see the bodies, but there was really no conclusive evidence as to how they came there and who had shot whom. This is all part of, I said, the fluid situation that prevailed throughout 1998 and 1999. That's Prosecution Exhibit 9 under seal T1882. I make that point because not only is this in the Limai case where counsel in this case did not have a chance to cross-examine had they wished to do so, but this wasn't even cross-examination. This was in response to the OTP prosecutor at that time. This is evidence in chief, not in response to a leading defense question. Other counsel have also commented on paragraph 101 with this completely misleading statement that days before the 19th of May Serb attack, ... This is in relation to count 1 when the 3 left Dolce. Days before the 19th of May Serb attack, paragraph 101. And in a footnote, the OTP cites to witness 66, who, as you have heard, does not say anything about days before the 19th. He says on the 19th at 9:30 in the morning. His testimony quite explicitly not only says it's the 19th, he said it was a Tuesday. And I ask you to take judicial notice, and we can all zip back through our computerized calendars and find out that indeed on the 19th of May 1998 it was a Tuesday. This attempt by the OTP to reconcile these witnesses with witness 80's testimony is at best inaccurate and at worst a deliberate misrepresentation of the evidence before you. As Mr. Emerson has said, it means that you cannot rely on any of these footnotes, unfortunately, to support the propositions they stand for, or they purport to stand for. The only reason they claim it was days before is so that they can tie it to one of the many different pick and mix versions told by Witness 80, the story they want you to swallow. This brings me to review the gross misrepresentations that have been made to you by a number of witnesses. So we don't like the word lie, do we? The failure to exercise any responsibility in relation to the quality of the evidence presented before you is frankly insulting to the intelligence of this trial chamber and to the integrity of this institution as a whole. The total failure to explain in their final brief what weight should be attached to the testimony of witnesses who have clear motives to lie and exaggerate, it beggars belief. The bland, shoulder-shrugging abandonment of Witness 81, well, never mind, just ignore him. This is not the conduct of a responsible prosecution. A responsible prosecution would never have put Witness 81 before you in the first place. The repeated presentation of flawed testimony is the one consistent theme in the prosecution case in this partial retrial. Your honours may be of a generation to remember Simon and Garfunkel's The Boxer. A man hears what he wants to hear and disregards the rest. You may also remember the chorus of that song, lie, 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 lie. It's the constant drip of prosecution misrepresentations. Witness 6, not that we put him forward as a witness of truth in general terms, but even he claims, and probably did, spend the longest time of any in Jablanica. He never mentions word one about people being put in a basement full of water. He never saw anybody beat Witness 3. He says in terms, Witness 3 was not beaten. Mr. Guy Smith has set out many of the details of the conflicts between Witness 6 and Witness 80, and we adopt Mr. Guy Smith's answers, points in their entirety. Witness 6 flatly contradicts much of the key evidence on which the prosecution relies from Witnesses 3, Witness 75, and Witness 80. That doesn't matter. As long as you pick out the flavours in the pick and mix bag that the OTP asks you to like. For example, paragraph 87 of the prosecution brief. There's a little throwaway line there that Yar Bushati was forced to join the KLA. Not according to Witness 75, he wasn't. There's no evidence from Witness 80 or anyone else on that point. It's just a bold, unsupported assertion. Paragraph 91. Jablanica was a no-go area for Serbs. Colonel Crossland said there was no such thing as a no-go area. Whenever they wanted to, the Serbs were capable of overrunning Jablanica, and they did so at least twice during the indictment period. On the 2nd of August, when they butchered Lahi Brahimai's mother and grandmother, literally cutting them to pieces. Count 1, as Mr. Guy Smith has rightly said, the question is not when these 3 young men were taken to Jablanica, but whether they ever were.
Your Honours, we're back in open session.
Thank you, Mr. Registrar. Yes, Mr. Harvey.
Thank you, Your Honours. As I was saying, the
Microphone for Mr. Harvey, please.
Microphone, Mr. Harvey.
My apologies. Thank you. As I was saying, where the prosecution say the only reasonable interpretation of witness 80's evidence, all at once alarm bells have got to start ringing. Is this their new definition of beyond reasonable doubt? The trial chamber should not have to rely on the OTP's selective interpretation of the evidence. If the evidence doesn't speak clearly and consistently for itself, it cannot be said to be established beyond a reasonable doubt. In relation to counts 2 and 4, they have been covered by my colleagues. I would make only this point. Search the OTP's case as you can. Search their final brief. They do not cite to anything that any witness has said before you. They only cite to the previous trial. Well, I appreciate that this is a retrial, but if there has been no fresh evidence on counts of which my client has already been acquitted, then in my submission those acquittals are good and should stand. At paragraph 151 of the OTP's final brief, they say, it is clear from witness 6's evidence that he did not see the beating witness 3 suffered upon his arrival. Well, they've got to say that because they've got to try and find some way of explaining why witness 6, whom they want as a witness of truth, and witness 3, whom they want as a witness of truth, have a complete inconsistency. But it's worse than this, because that isn't what witness 6 said. He did not say that he didn't see the beating. He said specifically that witness 3 was not beaten, and he was only there for a relatively short period of time. That is at Exhibit P84, transcript pages 5235 through 5336, which we invite you to review as you look at the evidence of witness 3 on this point. Never mind, say the OTP, just pick those bits of witness 3's testimony that we tell you you should accept. Ignore the contradictions between 3 and 6, just as they invite you to ignore the contradictions between 6 and 80, 3 and 80, 3 and 6 and 80, 75 and 80. I'm sounding like a bingo caller here, but essentially they want you to ignore every contradiction with which their case is full. And of course, you should forget all about 81. Is this the new OTP standard of beyond reasonable doubt? In relation to count 6, I've said a little bit already about Lahi Brahimai's role, as we say it was. And I refer again to the prosecution's brief, paragraph 235 and 236, where they describe Lahi as a near constant presence in charge of Jablanica. The exhibits that you have in this case tell a very different story. P204, perhaps we could call that up. Could we please, Mr. Registrar, P204? Can you switch the screen so that I can see some? And if we could have the English version as well, please. Thank you. And could we go to the next page, please? If we just highlight the last 4 lines on that page. Caution for Lahi Brahimai. When he moves out of the operational zone, he has to inform. Again, something I don't think we need to bother too much, although the next words obviously relate to that. But a caution to be issued to Lahi Brahimai as a result of his being out of the zone. That's on the 1st of July. If we could now have P161, please. Thank you. And could we go to the next page again, please? Oh, wait a minute. Sorry. I have called up the wrong exhibit. I do apologize. May we go instead? I've obviously got confused over exhibit numbers. I'll find the right exhibit. Meanwhile, if I could just quote from it, and I'll get the right number for your honours. This is the 4th of July meeting where a reprimand is issued to Lahi Brahimai in these terms. Following our request for a working meeting that, due to your absence from the zone of responsibility to which you belong, failed to take place twice in a row, we address to you this reprimand from us, requesting you to carry out your work faithfully. Thank you very much. It's P211. I do apologize for that.
And is his zone of responsibility described? Do we know what?
Well, he is the deputy head of the Dukagjin zone at this period, Your Honour. That is the zone of responsibility as defined in the previous documentation that we have.
Thank you.
So, to Lahi Brahimai, Deputy Commander of the Operational Headquarters of the Plain of Dukagjin. I think that makes it very clear. Following our request for a working meeting that, due to your absence from the zone of responsibility to which you belong, failed to take place twice in a row, we address to you this reprimand from us, requesting you to carry out your work faithfully. We ask for this behavior not to be repeated. Now, clearly, 2 meetings were scheduled and had to be cancelled because Lahi was not in the operational zone. And why? Well, you've heard from Bislim Zarapi, you've heard from Jakub Krasniqi, you have heard the evidence that, of course, the headquarters that they were trying to set up for the general staff of the KLA were in the Berisha Mountains. You have heard that Lahi was responsible for finance and logistics. You have heard, therefore, that he had duties that compelled him to be wherever the general staff might be at any given time. Therefore, it is perhaps not at all surprising that within a very, very few days of his supposed appointment, or of his actual appointment as deputy commander, it is recognized that this is frankly a mistake, that it's not possible for him to carry that out, and we can see, if we could have exhibit P218, please, the result of that. Thank you. And this, as Your Honours see, is the next day from the previous exhibit. That was the 4th of July. This is the 5th of July. Lahi Brahimai is discharged from the service of the Deputy Commander of the Dukagjin Operative Headquarters, and Nazmi Brahimai is appointed as Deputy Commander in his place. This order comes into effect immediately. So, Your Honours, I think it's important to focus on this point because the constant or near constant presence claimed by the OTP of Lahi Brahimai in Jablanica, that his command responsibility there, this gives the lie. The exhibits put in by the prosecution give the lie to that claim. Doesn't mean, as I say, I'm being realistic, I hope. It doesn't mean that Lahi Brahimai was never in the village that he was born and grew up in. Of course he was there. But it does mean you have heard all of the evidence about the difficulties of travel by night, not being able to use the roads that were blockaded by the Serbian military forces. You have heard that it was a problem of communication throughout this period, and that the headquarters were a considerable distance away in the Berisha Mountains. And obviously, Lahi Brahimai was required to be there on a frequent, if not regular basis. That's all I say in that respect. Please.
Do we have evidence to say that he was there on a frequent and a regular basis?
We have Bislim Zarapi and Jakub Krasniqi say that he was there. I don't think anybody is able to speak of a particular degree of frequency. But it is, I think, Jakub Krasniqi, and I will have to find a reference on this one, I don't have it right at my fingertips, who says that because of his responsibilities as a staff officer, it was impractical and impossible for him to fulfill the responsibilities of an officer commanding troops in the field. So when he would be in Jablanica, that would be on a time-to-time basis, it would be on an as-needs basis. And we have plenty of evidence in this case that people did move around in response to an attack, in response to a sudden need from a particular village. People would be brought in very quickly. And I think there's quite a bit of evidence also from Bislim Zarapi on him traveling with Lahi Brahimai on an emergency basis in response to requests from the General Staff. But if Your Honours would like, I can certainly find page references in the transcript on that. I'd like to move, if I may, to a number of sections in our brief, which I have no intention, you'll be relieved to know, of reading to you, because I know that you will have read it already and that you will study it, I hope, in some detail and depth.
Mr. Harvey, just one moment. I suppose the transcript at page 6321 will be corrected, where it is said that it's Mr. Guy Smith that is speaking, while obviously it's you.
I'm grateful for him not interrupting me at this point, Your Honour, and for you drawing attention to that. Thank you. Yes, I see. I'm back in on the job. At page 7 of our brief, we have a section headed Credibility and Reliability, where we describe the prosecution case as a masterclass in the indicia of untruthfulness and unreliability. So, and Your Honours know at paragraph 18 on pages 8 through 10, we list criteria of unreliability and absence of credibility, because it's an interesting exercise to do. Just as a trial lawyer thinks of all of the areas where I see you poised, I see your light is on, I see I'm probably approaching a time at which you would like me to make a break.
We've gone beyond it by 5 minutes.
Okay. May I just finish making this point, and then I will break. Thank you. As a trial lawyer, you constantly think about the issues which demonstrate a witness to be lacking in credibility or reliability. But speaking for myself, and your honours may have different experience, I don't think I've ever been involved in a case in 40 years where I have seen every single one of these indicia of unreliability and incredibility demonstrated as clearly and as disturbingly as the prosecution case here. And with that, I will pause for half an hour.
Thank you very much. We'll take a break and come back at 12:30, quarter J.
All rise. Vive le lever.